Great, thanks, Valerie. So I think where we left the discussion last time was we started with talking about maybe keeping what we have in ORS, but looking at what's in ROLCA to see if there are elements of that we want to incorporate into ORS with respect to the merger provisions. And then we swung into the opposite direction, which is that we're going to look into just adopting what ROLCA has, but keeping things in ORS that we like. Um, did that Does that accurately summarize where the consensus was last time with respect to the merger provisions? Yeah, okay, great. Okay, so I'm starting with section 1021 of ROLCA. So this is part 2 of Article 10 of ROLCA. And so the part 1 we skipped over, and that has the definitions that will be important for part 2, but I think we can look at part 2 and refer back to part 1 for the definitions as necessary. So let's start with 1021. 1021 does really says mergers are authorized, that two entities, a domestic LLC can merge with a domestic entity of another type or a foreign entity of another type. The analog provision in that in the ORS is 63.481 subsection 1, and it doesn't do 1021 doesn't do a whole lot of new things. One thing that I'll flag on 1021 is that it does allow two foreign entities to merge into and create a new domestic Oregon LLC. So you could have, for example, a Washington corporation and a Washington LLC merge, and the surviving entity from that merger would be a Oregon domestic LLC. Some states refer to that as a consolidation because neither of the constituent entities of the merger would survive the merger. It would be a whole new entity. I think that's already allowed under Oregon law, ORS 63481. Subsection 1 seems to contemplate that scenario. What we'll see when we look at the rest of the provisions is ROLCA is very explicit about if you want to go that route, the things you need to do, whereas ORS is largely silent on the consolidation scenario. I'm not sure how commonly consolidations are used in practice, so I'm not really sure this is an important aspect that we want to dwell on or not, but I'll open it up to discussion. I don't think there's anything controversial in 1021. Like I said, it's largely covers the same ground as ORS 63481 subsection 1.
It's a pretty short section too.
Any questions or comments, or does anyone want to discuss? Essentially, like I said, all this does is say that mergers are allowed, that two entities can be merged into one, with one of the two entities surviving the merger, or it's possible also for a new entity to be formed out of the merger.
I have no problem with this.
I like it. It sounds good to me.
I'll say with all these provisions, there's not a lot of what I view as controversial. What I think all ROLCA does is, which is true in a lot of areas, just be more explicit and prolix, say things that may have just been unsaid in our existing statute.
Right. Yeah, and that's a theme we've definitely seen as we've gone through some of these other sections too.
Yeah.
Okay.
Okay. So we can come back to 10. We can come back to every one of the. I mean, these provisions are closely related, and so we'll come back. We can come back to 1021. So let's move on to 1022. Okay. So let me get my notes with respect to 1022. So the analog provisions for ROLCA 1022 are in the same ORS section 63.481, subsections 1, 2, and 3. Cover the same ground that is being covered by 1022 of ROLCA. So let's start with the first sentence of 1022 subsection A, which says a domestic LLC may become party to a merger under this part by approving a plan of merger. That's essentially the same as what's required by subsection 1 of 481 of ORS, that to become a party to a merger, the LLC needs to adopt a plan of merger. So nothing really interesting there. A1, so let's see, let me get my statute in front of me. Okay, so then what A1 through A3 provide is what's required to be in that plan of merger. And again, the analog provision is subsection 2 of ORS 63481 that specifies what needs to be included in a plan of merger currently under Oregon law. And a lot of it's the same. It's not the exact same in terms of words, but a lot of it's the same. You need to include the names of the entities that are a party to the merger, including which entity will survive the merger, a summary of the terms of the merger, and what happens to the ownership interest of the constituent entities that are a party to the merger. So this is covered basically in subsection 2 of ORS 63481. I'll make, well, any questions about what's in subsection A? I'll make a couple of comments. So if you look at ORS, the existing ORS, this is 63481. Like I said, subsection 2 of that part of ORS specifies what needs to be included in a plan of merger. Subsection 3 says that in addition to what needs to be included in a plan of merger may include any amendments to the articles of organization for an Oregon LLC if the Oregon LLC is the surviving entity. So in the plan of merger, if the Oregon LLC is going to be a surviving entity in the merger, you can include amendments to the LLC's articles of organization. What's not said in subsection 3 of ORS is that you can also include amendments to the operating agreement of the Oregon LLC if the Oregon LLC is surviving the merger. That may be implicit in 3B of ORS, which says that the plan of merger may include any other provisions relating to the merger. But that would be reading into that. That's not explicit. ROLCA is explicit on this point that under ROLCA 1022A4, it's explicit that if the surviving entity exists before the merger, so it's the surviving entity is one of the constituents to the merger and survives the merger, then the plan of merger can include any proposed amendments, not just to the articles of organization, but also to the operating agreement of the entity. So that's the reference in 4A. Public organic record refers to the articles of organization for a LLC, and 4B, private organic rules refers to the LLC's operating agreement. So ROLCA is explicit that when you're dealing with amendments in the plan of merger to the articles of organization or the operating agreement, those may be included in the plan of merger. ORS is silent on that point.
Yeah, and I just want to draw everybody's attention to the fact that public organic record is actually a defined term on page 189 of my printout. And it talks about basically what Mohsen has just said about what the documents are, but then it goes into a little bit more detail about what, because I don't think we have this concept really of an organic record under current Oregon law. So
no, well, there's a definition section in ORS, the merger provision. Let me pull up the definitions that uses a similar term, but it's not in this particular, it's not in the analog section of ORS.
Right.
And the way all these provisions, these merger provisions are drafted is that they are drafted in this kind of generic way because I think they're intended to be uniform across all business entities, which is why it's referring to public organic record and private
right. And I
rules.
just wanted to draw, and because of that, I just wanted to draw your attention to the fact that, you know, it talks about things like a deed of trust used to form a business trust as being a public organic record, which becomes relevant when we're talking about some other sections.
I hate to, sorry, go ahead, finish.
No, go ahead, Jeff.
Well, I spent this morning, because Michael and I are focusing on conversion, which is next up, and it's the same section. And so I was focusing on conversion this morning. And so I apologize to move us backwards, but I'm realizing that an issue that exists in conversion exists with mergers. And it has to do with entities, the definition of entities, which starts on page 177. And it's the same definition used in conversion. So I hate to back up to 1021, but I think we should look at the entities, because in the case of ORS, we have a definition of business entities. And in the case of, and that's in 63-467-1, business entity.
Right.
And we have entity, which is both, there's the word foreign and domestic in front of it used in the statute, but there's a definition of entities and it's different. And so I think we need to focus on that. For example, entity under ROLCA includes a nonprofit corporation. If you look at business entity under ORS, it doesn't include a nonprofit corporation. And then it talks about the ROLCA version, general and limited cooperatives. I don't think we have, I think we just have a cooperative.
No,
And
but
then it
Jeff, I think that what part of your concern is what we were talking about last week, last month, where we were talking about how, this section 10 is intended to be sort of a plug and play into all of these different acts. So to the extent that it makes sense to limit the scope and say, okay, we only want to limit this to the sub 5 limited liability companies, then that might be a possibility, right?
Well, yeah, I mean, yes, I think what I'm suggesting is we need to look at the definition of entity in ROLCA and consider how that plays and how we're going to plug and play going forward, because the definition of business entity is much slimmer in ORS. Again, nonprofits are not included, which is surprising to me. And then you have all these other things in the definition of entity, including a decedent's estate, a government or a governmental subdivision. So I just, again, there's a difference between where you can merge and convert under the current ORS, it's much more limited, versus what you can merge and convert under ROLCA, which is much more expansive. And then there's just things that are not consistent. For example, entity, it says a limited partnership, including a limited liability limited partnership, which we don't have. We have LLPs, limited liability partnerships, but not LLLPs. So there's just, again, that was one of the issues I was going to bring to bear at the beginning of conversion is there's a big distinction on the entities.
I think that's a worthwhile discussion to have. I mean, we knew that some of these definitions were going to require editing as we go through, right? And obviously, if we don't permit a type of entity, then we probably shouldn't discuss it in the statute proposal.
Well, I agree with Jeff. I was going to just cabin those issues because I think, Jeff, the issue you raise is one that becomes relevant as we think about, do we really want to try to adopt these provisions of ROLCA wholesale? Because if we do, then we have to pay close attention to the definition section, as you suggested. So what my plan was to kind of walk along through what ROLCA does with respect to mergers, and kind of cabining those, I think, intricate issues that will require a lot of time and attention. But Jeff's absolutely right. It's kind of hard to talk about all this without focusing on how the definitions are different than what's in ORS.
No, I agree. And I think that's going to be true as we go through section 10 generally. So thank you, Jeff, for pointing that out. And I think we'll like I said, like Mohsen said, I think we'll put a pin in it and then we'll talk about it more globally once we've had a chance to go through all these sections.
Okay, again, I just a quick overall caveat. I thought we were going to roll through these sections quickly. When I plugged in the conversion, I was like, oh my God, it's very different than what's in the ORS. And, I think we're going to bog down a little bit in Article 10 more so than I thought. At least that's my impression from looking closely at the conversion.
Yeah, but I think if you can set aside the cognitive dissonance as we're going through it and just look at what is in front of you. Right. And then we can address the cognitive dissonance once we've had a chance to go through all of the sections. Listen?
Okay. All right. I was ready to get into the cognitive dissonance.
No cognitive dissonance today.
Okay.
Well, I mean, I think we can go through the merger sections pretty quickly, and then we can, if just once, we can start teasing out, does it make sense to try to do this wholesale given the differences in how things are defined?
Well, one thing I noticed as I was going through the conversion piece is like, it seems like every other word is a defined term.
It is.
There's a lot of definitions that you have to keep going back to part one. I mean, if you look at part one, it's like 25, 30 pages long of just definitions.
Yeah,
Right.
and
Part of the reason that I would like to wait is because I also like to have David be involved, and he's on a call for the next 30 minutes, so can't join us until then. So yes, Roberta.
So I think I heard someone say this before, and I apologize if it's already gone over with, but it looked to me like ROLCA does anticipate you might have a merger and then a totally new entity would emerge from the merger, and ORS doesn't seem to do that.
Right. Correct.
well,
Okay.
so I think ORS does contemplate that in one sentence, but otherwise doesn't seem to address the situation. Whereas ROLCA expressly contemplates it and deals with it in multiple provisions.
Yeah, does anyone have a problem with saying that we should be thinking about allowing this totally new entity? I mean, is this something that happens, or is it a problem?
So some jurisdictions wouldn't call that a merger; they would call it a consolidation, to take two entities, fuse them into one, and have a new entity result from that fusion. But some jurisdictions just refer to that as a merger and don't make a distinction. At least with respect to the LLC statute in Oregon, it seems like it contemplates that possibility as a merger. But like I said, it doesn't really set out the steps necessary to do that. I'm curious from the transactional lawyers how many consolidations they've done in their time, or they always do mergers where there's at least there will be one constituent of the merger that will survive the merger.
I'll jump in. I've never done one. I could envision it being useful in an odd situation. I don't know that we can't accomplish the same result today just filing articles at the same time you file an articles of organization for a new entity. So it just seems to be kind of fleshing out the options in a better way, but not creating something new that we couldn't accomplish today.
Yeah, that's my sense. Go ahead.
I've never done one before either, but let me ask a question. What's the difference between merging two entities where one survives and consolidating two entities where you call the resulting entity a new entity? What's really the difference? What's the value? Unless this is tax driven, because there's the type D, type E reorgs and all that stuff. But what's the difference? Can anybody tell me?
So I think your constituent entities that you start with are both non-surviving in that scenario.
But what's the difference between two entities that merge and you have one survivor, and two entities that consolidate and you have one survivor, but it's considered a new entity? I mean, what's the value to that? I mean, don't you end up in the same place? You merge two entities, you consolidate two entities, you have one survivor, and they probably have the same effect, meaning the liabilities of the two end up inside the one.
But I would think that for example, for unemployment insurance rates, right? You may have two entities with relatively high unemployment insurance rates that, you get a reset on your experience rate if you have a new entity come out of it. I mean, I can see that's maybe one situation where it would be useful.
It also might be if they want to change the name rather than, having a surviving entity, then changing the name of the surviving entity, kind of doing it all at once, might have some efficiency.
Yeah. But it would be only very modest, because you could easily accomplish the same thing by just forming a new entity and making it a constituent to the merger.
Yeah, I mean, I'm not opposed to giving people new tools though, right? I mean, I can see like limited situations in which this might be useful. And, we have had situations where people truly wanted to move forward as a single organization, and this seems like a cleaner way to do that than sort of the mechanisms we've had before.
I'm curious to what Mohsen just said, which is, if you do a consolidation, again, I've never done one, do you form a new entity and then merge the two existing ones into the new one, and that's how you end up with the new entity? Or you just consolidate the two and somehow they end up being a new entity without first creating a new one?
So this is where ROLCA expressly deals with this in a way that ORS doesn't. Under ROLCA section 1022 A5, it's explicit that if the surviving entity is essentially created by the merger, which is what we're talking about in this scenario, then the proposed public organic record needs to be included in the plan of merger, right? So the document that would be the formation document for this new entity is a part of the plan of merger.
So you would form, in other words, you have to form a new entity and effectively merge the two existing ones into the new entity. The two go away and the new entity is the survivor.
Right. Yeah. And so that's very close to just what you could already accomplish without doing a consolidation, right? And so it's not clear to me what the value of this is.
One filing fee instead of two. That's the only thing I'm hearing.
Yeah.
Teresa,
Speak,
did you
Teresa.
have a comment?
I have a question. And it really is in sections 4 and 5 of section 1022. And it's been a couple of decades since I've even had my hand in doing a merger. So I admit I don't know much about this area, but it says that the plan must be in a record and must contain the items in 4 and 5. And the public organic record parts of that make sense to me because that would be the same information you would normally have in your formation documents that become part of the public record. But does it bother anyone that you have to include either the full private organic rules if it's a new entity or the full or the amendments to the private organic rules? Because I thought part of the point was your LLC operating agreement got to be secret.
Yeah, so 1025 talks about what needs to be publicly filed, and it's not necessarily the plan of merger. So the plan of merger will include that operating agreement, but the plan of merger doesn't need to be filed as the public document to effectuate the merger.
Okay, so this is what has to be in it, but not necessarily what has to be on the public record.
What this not talking about the filing that's necessary to actually affect the merger.
Okay, that's where I was confused. Thank you. That helps a lot.
That's interesting though. Isn't that a change from the ORS where you do have to file the plan of merger in the plan of conversion as well? Isn't that a change?
You don't have to.
No,
You
so
don't have to. You can make it available and say that it's available at the office of the company.
Right. Right. Gives you a bypass.
So it looks like there's maybe another thing in 1022A1 that I didn't see in ORS, which is that each merging entity the record has to contain the jurisdiction of its formation, which makes a lot of sense to me, but I didn't see that in ORS.
So yeah, I didn't see it as a controversial change because I think that's the way documents are drafted as is.
They should be. I mean,
They should
I
be.
looked at one not too long ago that didn't have that in it.
Yeah. Okay. So it's different, but that's good.
I have, I'm basically fine with 1022. I have 3 questions. One is, I noticed that the Oregon statute, there's 2 points of difference from this statute. One is in 1022A3, where you have to talk about the manner of converting the interests, and Oregon statute says you have to put forth the manner and basis of converting the interests. And frankly, I'm not sure I actually know what that means and whether it's a substantive important change.
I didn't read that as a substantive change, but I'll let any of the transactional attorneys correct me. Basis means something different than manner. I think basis means what is the conversion ratio or exchange ratio when you're trying to determine what the merger consideration proceeds to
Basis
individual
means something for tax purposes, but I don't know if that's what they're referring to.
No,
I don't think that's what's happening here.
I'm pretty sure it's not what they're referring to.
no, I agree with Molson's interpretation of basis. I didn't. It has the same issue in the conversion plan of conversion, and I noted it, but I didn't think it was a big deal.
Yeah.
Okay. And similarly, in A6, you have to include the other terms and conditions of the merger, and the Oregon statute says the other material terms. It seems like we're all cool with that. And the other thing is,
so let me just chime in there. That's based on language from the MBCA. I noted that difference as well in the ORS, and when I saw that material language, I kind of was puzzled by why that is. I think that the practice now is that plans of mergers include all the terms, not just the material terms. It would be highly unusual, if not malpractice, to just write down the material terms and leave the immaterial terms unsaid.
yeah, and who decides?
Right.
Okay, that sounds great. And my other thing was, and I'm curious, maybe this has to do with the way that this is supposed to be plug and play across all the other different entity acts or what have you. But it's so weird to me that A2 provides for something that you need to do if the surviving entity is to be created in the merger. And then A5 provides what you need to do if the surviving entity is to be created in the merger. Why wouldn't you just have the provisions of 5 be in 2 also? And therefore you'd have one section that talks about what you need to do if the surviving entity is to be created in the merger. It just seems to me strange drafting to essentially have 2 different sections where you're talking about the exact same thing.
I don't think it does seem strange, actually, Cody, because 4 and 5 both talk about what needs to be in the record under 2 different circumstances, right? So they're both talking about what needs to be in the record, and I don't think that's what 2 is necessarily talking about in the same way. But that's just my view.
I see what you're saying, Cody. I think it's idiosyncratic. And you can make arguments for either way of drafting. I don't think it makes a substantive difference, and I don't find it particularly confusing. I
don't ultimately have a and it's just, I think it's strange, like, you know, to have it, you know, if I give you an apple, you have to do X, and then later on I'm like in a totally different, you know, 3 sections later, if I give you an apple, you have to do Y. Like, why didn't you just tell me both X and Y the first time? But I just was curious if anyone knew why it's drafted strangely, but I don't care. I vote we approve this section.
So the only, I mean, I think that the big change or potential change that this section would introduce is the possibility that a plan of merger could include amendments to the operating agreement.
We do that today.
Okay, so that
I mean,
that happens.
I've done that. Yeah.
That happens under 3B of ORS 481. Okay. All right.
Yeah, the other terms concept. Yep.
Okay. All right. Well, so then Rockland just makes explicit what at least is happening in practice today, whether it's allowed or not. I guess hasn't been tested, or maybe it hasn't. I'm not aware of the case law. So I don't think there's a lot of controversial things in this provision if that already happens today. Again, putting Jeff's concern, which I share, which is that a lot of these are defined terms that we'll need to go through with a fine-tooth comb to make sure they comport to or are consistent with what we have elsewhere in our ORS. Any further discussion on this? Like I said, we can come back and revisit this one as we go through the other sections because they do all interrelate. Okay, so 1021 said mergers are authorized. 1022 says to do a merger, you need to have a plan of merger. 1023 deals with how a plan of merger gets approved by an LLC. So let's move on to 1023. And here we can start with A1. A1 is says that a plan of merger may be approved by a Oregon LLC by approval of all of its members. So it requires the unanimous consent of all members. This is different than what's currently in the ORS. The analog ORS provision is 63487, and under 63487(1)A, what's required is not unanimous consent of all members, but a majority vote of all members. That's a majority vote, not based on your ownership interest, but per capita, each member will get 1 vote. Note that in both cases, ROCLA and ORS, these are merely default rules.
Right.
So what ROCLA would do is have the effect of changing the default rule from one of majority consent per capita to one of unanimous consent.
Well, it's all the members entitled to vote on the thing, right?
Fair enough. Fair enough. You can have non-voting members. I don't have a problem with this, and I think this is probably the better default rule to the extent that a plan of merger could include provisions that amend an operating agreement. I think it makes sense that the default rule should be that anything that could have any changes to the operating agreement should require the consent of all the parties to the operating agreement.
I would speak for retaining the current majority rule. Jeff's smiling, he already knows why. When you have multi-member LLCs, it gives a unanimity requirement gives too much leverage to your loan holdout who tries to extract some ransom. So I personally would speak for retaining the majority vote.
And I would agree. And I would point out that quite often operating agreements are not going to address specifically a vote for a merger. So sometimes they're just going to be silent. And again, it requires real thought for all this stuff. And by the way, just a quick aside, most of the issues that Mosen's bringing up on merger are identical in the conversion stuff. So essentially we're talking about both here. Conversion does the same exact thing. It says all members have to approve, and ORS is majority. And I would favor majority.
Does it worry you too that this would essentially create a back door to maybe it's not a back door, it's a front door to amending an operating agreement with less than unanimous consent?
Yes.
Because
I mean,
you could affect an amendment.
concern me.
You can create an amendment through a merger, right? And maybe this happens already. And I know there are fiduciary duty constraints, right? But that's not something that I want my client to have to rely on in trying to enforce fiduciary duties.
So
for them,
you're suggesting that the operating agreement says it requires all to amend, and a backdoor way around that is do a merger and amend.
Yeah.
It's a big draconian step to amend an operating agreement, but I understand what you're saying.
What did we say before when we talked about amending the operating agreement? What does, I mean, that was some
That's what I
prior
was just
section
looking for.
said, you know.
Is the default rule majority, in other words, unless the operating agreement provides otherwise.
Right, well, yeah, whatever the default rule we had before, I would think we ought not to change it here.
that I would agree with that.
I guess I was remembering on amendments, unanimity was the default rule, but maybe I'm not, a lot of this blurs together.
Well, and that would be consistent based on Mosen's argument. Perhaps we need to be consistent in merger and conversion with what the default rule is on the operating agreement amendments.
Right.
Why is it so hard to find the darn section?
It's not in the index, but I think it's it's in 105.
Actually, 105 or 106.
Yeah.
Probably 105 it should be in.
That's what I'm thinking.
The comments also point out that another reason for this default rule is that because appraisal or dissenter's rights are not available by default under RULCA, this essentially provides a mechanism for minority protection, because if a minority does not agree to a merger and we go to a majority rule, then they're stuck with the merger and don't have that other layer of protection that appraisal or dissenter's rights might otherwise provide.
But if it was a majority, then you would need to look at what it would require to make changes to the operating agreement in terms of what's in the plan, right?
I'm sorry, I didn't follow that, Jeff.
Well, I mean, what's in the plan of conversion can include provisions that amend the operating agreement, right? So what does it take to approve the plan?
Well,
And the default, I'm sorry, I'm looking back. Well, I'm looking at the conversion. I'm looking at the wrong set of rules.
yeah, 1023 requires all members to approve a plan of merger as the default.
So maybe it needs to be consistent, but I'm wondering if that protects against it. I mean, if you can, maybe it doesn't make sense to be, majority to approve a merger, but unanimity to approve the plan of merger. I mean, that would fix the problem with your suggestion, Mosen, of changing the operating agreement, because unanimity would be required in the plan by default to approve the plan, which would have the changes. But I'm not sure it makes sense to say majority merger, but unanimity on approving the plan.
That's not what I'm suggesting. What I'm suggesting is that the comments to 1023 provide that the rationale for unanimity is because there's not backup appraisal or dissenter's rights to protect non-consenting members. And so because there's no other protection mechanism for a member who might not want to go along with the merger, their approval is what's required by the statute as a default rule.
So, Rolka commentary on page 27, it says that under 105A4, the operating agreement can provide for whatever quantum of consent is going to be required for amendment of the operating agreement, which can be a mere majority, for example. And then it says, if the operating agreement does not address the issue, this act provides the rule. Section 407B4C and 4073C3, or I should say C3C, each require the affirmative vote or consent of all the members. So I haven't yet looked at 407, but it seems to require all the members to consent.
Yeah, what 407A4 says is, or sorry, B4 says is the affirmative vote or consent of all the members is required to amend the operating agreement.
And we
That's what
had
you're looking for.
right, and we agreed to that before, and not that we couldn't revisit it, but amendment to the operating agreement requires unanimous consent, and if that's our position, then I mean I agree with most, and we shouldn't allow people, even if it seems a little unusual, we shouldn't allow people to accomplish through merger what they couldn't accomplish through direct amendment of the operating agreement.
And I'll reiterate, this is just a default rule. And you could easily have a term in an operating agreement that says that on all matters on which members are entitled to vote, a vote of a majority of the members on a per capita or pro rata basis constitutes the required consent of the members. And that would opt out of the default rule for all the unanimous requirements that are set forth in roll call.
Yeah, and I like Michael's carpet layer kind of people when we're thinking about default rules. What's your basic your person who's hiring James to do their corporate paperwork is probably going to be sophisticated, thinking about these things. It's easy to throw in a majority consent for operating agreement amendment / merger, etc. But for the people who are just they don't have a written contract at all, and they're just at the mercy of what the statutes provide, I kind of think we should stick with what ROLCA provides and consistent with our prior decision on section 407.
A point I would make is I scratch my head here and say, okay, well, why is ORS 63 a majority? And I think just looking at the history of 63, I think it's really borrowed from the Corporate Act. So if you look at the Corporate Act 60487 down in sub 5, the default rule there is majority of shareholders. So I think just to put it in context, why is our current law what it is? Well, it's just borrowed from the Corporate Act. So we would be making a difference in terms of both 63 and ORS 60 if we shifted to unanimity. I could make arguments going both ways, just looking at the issue in isolation in ROLCA. But I think consistency amongst the entities in this area particularly is something that we should take into account. It's not necessarily drives the final decision, but the consistency amongst the cross species, because we're dealing in an area here where the cross species of constituent entities coming together. And you could end up with some anomalous results if you have a corporation and an LLC involved in this process. And so I guess I'd caution us to be careful about this.
This raises the kind of interesting academic question of what's the appropriate analogy here. Should this be treated in this area? Should LLCs be treated more like corporations or like partnerships? And I think with respect to amendments to an operating agreement, I think members of an LLC think of an operating agreement much more like a contract, whereas a corporate charter and bylaws are things that are subject to majority rule. And so I think that's my intuition. So I feel more comfortable with the unanimity requirement here, and that's what would be required under partnership law as well. But certainly that would be out of step with what corporate law requires as a default rule.
Well, and you always have the possibility that you're going to have different entities merging that have different standards, because there's the possibility of merging a foreign entity in, and in other states or other countries, they certainly could have a unanimity requirement where Oregon only currently has a majority requirement. So I don't think that's really creating anything different than what we have. It's just, it creates something new between domestic entities that we don't have. But I actually found what Mohsen just said to be pretty persuasive. My sense is that people who join LLCs think of them more as contracts than they do anything else. And I think when we're talking about the carpet layers and what would they expect, I think they would expect that they'd all have to agree before they would amend their contract.
So in the hypothetical situation where you have a corporation merging with an LLC, these rules, these default rules that require unanimity, that would presumably just apply to the LLC members and not necessarily on the corporate side.
That's absolutely right. 1023A1 only applies when we're talking about an Oregon LLC as a constituent to the merger, what's required for that Oregon LLC to approve the plan of merger. And what's required is...
Right. This would be protective of Michael's carpet layers.
Who formed an Oregon LLC.
Mm-hmm.
Yeah, I'll add that existing ORS seems to contemplate the default rule that all amendments to the Articles of Organization or Operating Agreement must be unanimously approved by the members. So there's already a unanimity requirement with respect to operating agreement amendments in ORS. We've seemed like we've carried that forward into ROCLA, although we can revisit that. And so it makes sense to incorporate it here with respect to mergers that can have the effect of amending the operating agreement.
Yeah, and I also think that in addition to the points Mohsen and Teresa were making, it may be that today ORS Chapter 60 for corporations has a different standard, but that also just raises the question, or ostensibly us or some, shifting version of us is going to go through all the different entity acts. And so, this is in a sense that chicken and egg problem, which entity did we go to first? And it happened to be LLCs here.
Can I kind of want to make my point, flesh my point out a little more if I could, because I do think this would be a pretty significant and meaningful change, at least for people who engage in M&A activities. And the way I typically think of a deal when it comes in the door, if it's an Oregon business, I know that I don't need unanimity unless my client and the members and owners have written that down somewhere and agreed to it. I know that if I have a majority in front of me telling me we want to go do this deal, I can get it done. If it's an Oregon corporation, we convince everybody it's a good deal. And if somebody holds out and thinks they have, we're going to get more value from some other transaction, great, we can do the deal anyway, and they get dissenters' rights. And there's a trial to establish whether they were correct about value or whether we were correct about value. For an LLC, we know we can use a merger to squeeze someone out. That's the pejorative way of describing it. And we're subject to all the fiduciary constraints. So there's a way for people to get protected. And I'll grant you, it's not the same framework that dissenters' rights would have in this corporate context. And that's another conversation for another day. Should we have dissenters' rights for LLCs? But I fear if we go to a unanimity requirement, we're going to create a situation where anyone who wants to sell an LLC, if you've got multiple members, any one member can hold that up. And I fear what people will do with that leverage, because that's the ultimate veto card.
James, so can I propose a compromise position? And I don't have a strong feeling on this question. I think there's legitimate arguments on both sides. But maybe a compromise position would be that mergers may be approved by a majority of the members unless the plan of merger contemplates an amendment to the operating agreement, in which case whatever consent is required of the members to amend the operating agreement would be required to approve the plan of merger. That might already be implicit in the statute. I just don't see it explicitly there. But if we made it explicit, I think that deals with the concern that this whole conversation has been about, which is one of using a merger as a backdoor to amend an operating agreement with less than unanimous consent.
I mean, I kind of feel like I don't know. I mean, there's a bigger philosophical question, right? That I don't know that there's an easy path to resolve. I mean, I think most of what you're proposing is what could be an easy path to try and resolve the bigger philosophical question. You know, and for me, it gets back to what Teresa said about what do our carpet layers expect? Because, you know, most people who have sophisticated or even relatively unsophisticated operating agreements will have this addressed in the what do the members have to vote on section of the operating agreement. You know, it's the people who don't have the written operating agreement who are going back to, you know, the statute as their default that I'm more concerned about in this situation, because you can vary the voting thresholds in the operating agreement.
I will, for what it's worth though, honestly, more than half the deals I do come to me with org docs that were either legalzoom.com or it's a 10-page operating agreement or less. I mean, it's the carpet layers who didn't know that they were going to become, you know, a franchisor that's across 12 states. And by the time they come to me, that's the first time anyone is asking them these questions. They haven't ever, and frankly, they don't even know what's in their operating agreement. They have no clue what's in there. They've never pulled it out.
Yeah, but what is their expectation? I mean, not what makes it easier for you to get the deal done, but what is their expectation about, you know, who has to be consulted on a deal? You know, that's my thought, is that, you know, I think I agree with you. The loan holdout's a pain in the ass, but bye Michael. But the issue that I have is that, you know, it's about expectations and what are people's expectations about how they interact with each other. And I kind of fall out where Teresa does. I think they would all expect to be consulted and they would all expect to have that vote. I mean, even though it is a pain in the ass.
But a vote, and that in my mind, when people come wanting to do a deal, wanting to sell the business, I think most people do expect it's a majority vote.
So James,
I don't think anybody, I mean, if you have a 10-member LLC, I don't think people expect that one person can hold it out.
I'm curious, you were describing these people having their, you know, LegalZoom LLC operating agreements, which, yeah, that's really common, or, you know, or whatever website or their prior deal they got it from. I'm curious how many of those operating agreements that you see require unanimous consent. My assumption is that they all just say majority, because those ones you can get off the internet are usually the sort of max power operating agreements and not the max, you know, fiduciary duty protection of minority type operating agreements. Because you had said earlier that you always, you know, Oregon law, I just know as a baseline, it just is pure majority. But even under current Oregon law, that's changeable by the operating agreement if they want to agree that it has to be unanimous. I'm just curious, how often do you then, once you start working on the deal, find out, it does require unanimity?
I would say more often than not, it's a majority rule, and more often than not, it wouldn't specifically mention merger.
And let me just add to it. In everything that James has said, I'm with you, James. I'm right behind you. I would say sometimes, for example, rarely do you ever see an operating agreement refer to conversion. So this same issue is going to come up with conversion, and this conversion is a new concept. I mean, Oregon adopted it.
Yeah, we're going to talk about conversion next time.
No, I understand that, but the point being is you see reference of merger more often, but not always. And I almost never see unanimity. Sometimes you see in operating agreements are drafted with super majorities, like 75% requirements, but unanimity, I almost never see it as unanimity because again, you can have the 1% holder hold up everybody and hold up the whole transaction. And often they're holding it up for personal reasons that
Right.
you
No,
know, are not legit.
understand that. I understand that. But you know, what these major life cycle events, right? I mean, my belief, and this is where it would be helpful if we had that woman from the small business clinic on. You know, my belief would be that the major life cycle events like liquidation and merger and consolidation and, you know, major amendments to the operating agreement, that those people would be either supermajority or unanimous in their approval of them because they're so consequential for the entity.
Let me, can I chime in unless anyone who hasn't spoken yet? So I think I've been persuaded by Jeff and James, and I also the one thing that hasn't been noted yet, but we should, which is that if we went with unanimity, that would be a change to Oregon law, and so that would be a substantive change. And so we should be mindful of whether we should make any substantive changes as opposed to just improve what's in Oregon law. On top of that, you know, I'll add that the concern I had was not about unanimity with respect to mergers. The concern I had was using a merger as a backdoor to amend an operating agreement, which would otherwise require unanimous consent. As I see it, there's nothing in the statute that prevents a majority of members using a merger to accomplish an amendment they otherwise could not accomplish because they couldn't get unanimous consent to the amendment. And that's my single concern. But with respect to mergers alone, I think unanimity is too high of a bar for a default rule. Jeff, though, I also wonder if you're overstating your concern, and James too, when you say that most operating agreements don't address mergers or conversions specifically. Most operating agreements, or many, will include a kind of blanket provision as to what kind of threshold vote is required to constitute an action of the members. And those will typically say that on any manner or matter that a member is entitled to vote upon, a majority of members' vote shall constitute an action of the members.
That's true. I mean, I agree that there's always the default provision because, you know, no operating agreement is going to list every action that you can vote on. And so they list the actions. And again, sometimes you list the actions have supermajority for certain actions like merger. I often will have that where I'll set a higher bar for a merger, but never unanimity. And there is the default rule. And the default rule generally in operating agreements for all actions that are not listed is majority.
Right. And so that would cover this. That would opt out of this default rule in my mind.
Would it though? That's interesting. Though, well, would it? Because it's not expressed.
Have to ask our litigators.
Yeah, that's an interesting question though.
I still have the issue most in Henry. I don't think Oregon statute I don't think it explicitly authorizes you to accomplish the operating agreement amendment through the backdoor vehicle of a merger over a minority opposition. I see, you know, there's that plan of merger can contain other terms through which, you know, I understand James would argue that, yes, you can do that because there's no limitation on what those other terms can be. But on the flip side, I think you could also argue that this merger statute isn't contemplating that when the other statute explicitly says the default rule for amending the operating agreement is unanimous consent. There's no indication the legislature intended to grant the merger statute what it prohibited in the operating agreement amendment statute. And so I think that, I kind of like Mosen's proposal that he had said before, that you can do the merger with majority consent, but if you're amending the operating agreement, then you need unanimous consent as to that. And that keeps the playing field level. And I know that there was mention of dissenters' rights and fiduciary duties, but if I recall our prior discussions, there's voices in favor of strictly limiting the fiduciary duties and the dissenters' rights. And so I don't, I certainly am a voice in favor of strong dissenters' rights and fiduciary duties. And so I don't want us to, in particular, say, well, we've got those as a fallback and then not give those much teeth either.
I'm going to even fall back further to Jeff and James' position, I think, which is, now that I think about it, if the sole purpose of the merger was to accomplish an amendment that you couldn't otherwise accomplish to the operating agreement, then that is a classic fiduciary duty scenario. And so maybe the answer is to adopt ROLCA's majority or retain ORS's majority requirement with respect to mergers, but include in the statutory notes an express reference to naturally, if the merger sole purpose is to accomplish an amendment to the operating agreement, that would be a breach of the majority member's fiduciary obligation to the minority.
I like that approach, obviously. And I will say pretty much every merger does involve an amendment to the operating agreement. I mean, especially if you're engaging in M&A, you're selling the business.
Right.
The buyer is going to restate the whole thing. It's going to be completely different. So there's a way to draft around that probably, but and I would be receptive to that. I mean, if that's what it takes to get people comfortable, I could get behind that. But I do think what you just landed on, Mohsen, is true, that if you're really just trying to oppress the minority, there's a claim there.
I just want to be clear, is there, from the discussion, just from my notes, do we have any language that we've agreed on, or is this just more
No.
concept? I just want to make sure.
No. Yeah, I don't see a consensus. Well, I see a majority that seems to be in favor of the unanimity requirement in ROLCA, but I don't see an overwhelming majority. I think there's at least a group of us that would prefer the majority that ORS currently provides. So I don't really know, Valerie, how you want to resolve this impasse.
Well, as Jeff has pointed out, we're going to have the same issue when it comes to consolidations. So why not? And I would like to have David and Michael present for a vote on this, because I think their perspective is valuable as well. So let's put a pin in this, and then we'll talk more about it next time when we talk about consolidations. Because
the idea, Valerie, being consistency, right? What we do, we'll do in both sides, merger and conversion. Okay. Yeah,
because when you look at what Cody pointed us to on page 98, it's talking about member managed LLCs, but the affirmative vote or consent of all the members is required to, and where we're in space we're in right now is the undertake and act outside the ordinary course of the activities and affairs of the entity. So I think that we need to be cognizant of the impact of our decisions on, and then we need to go back and look at 407 and maybe change that if appropriate.
Can I make one point that I don't really know how this cuts, but just one thing that's occurred to me listening to this discussion is that if you change it, so where Mohsen and James are coming out that this would be a fiduciary duty issue, what I see is that you're setting yourself up for very contentious, fact-specific litigation with tons of discovery about whether a merger was pretextual or not. Mm-hmm. So, that's great for litigators like us, because that will give us lots of work to do, and clients will be, you'll have to be defending your merger and dealing with very onerous discovery potentially. And it could, so you could have just a litigation tactic that could create just as many problems for your proposed merger as the unanimity requirement. Just my preliminary thought. I haven't really thought through exactly where the current statute is on this, how things would change or any of that, but
I think that's a really good point, Kyle. But I think that's a good point that we'll have relative to both of these major life cycle events. So can you give it some more thought, and then maybe share the results of your thinking with us when we get to the larger discussion? Please?
I'd be happy to. I'm not sure that the results of my thinking will be all that informative, but
well, Kyle, I'm not sure if you're for or against based on that discussion.
I'm not sure either.
Just litigation. That's good for you.
Well, I mean, it just strikes me that what Kyle was saying is, basically you're sort of a hoist no matter which way you go, because if you go with the unanimity, then the potential might be that you've got the minority owners holding up the merger. And in either case, if you go into litigation or if you've got the minority shareholders holding up, I think what we're talking about in the merger is generally it's a deal, right? Is you've got somebody who wants to acquire the company, and then somebody who wants to, that a majority maybe wants to sell the company. It's going to fall apart, right? Is this deal going to fall apart? So I don't know.
If we have unanimity, if we have unanimity, it will fall apart. That's why I like Kyle's point is a good one. And that's okay. I think the majority should have the right to decide, do we want to engage in the merger? Do we want to sell the business? We know there's one holdout. They're going to sue. They think it's worth more. They think it's a breach of fiduciary duty. We can take that risk. We can go ahead and do it and not lose the buyer, rather than the alternative, which is if we have unanimity, what are we going to do? File for dissolution to get a court to order the sale? In which case, by the time we get to a judgment, my buyer's gone.
Yeah.
So, I mean, the situation. Go ahead, Jeff.
You have minority rights. One of the reasons you have those minority rights is to give the minorities who do not want to do the merger, gives them some specific rights. Now, of course, they're much more statutory in the corporate side than they are in the LLC side. And then there's the whole fiduciary duty stuff with respect to ROLCA and that. But that's one of the reasons minority rights exist, is to provide certain protections to the minority who are having a merger or conversion done against their will.
Okay, so Jeff, I have a Post-it, and my Post-it says we're going to talk about this next time, after when we're talking about conversion. Mohsen, back to you.
Well, sorry, I wanted to dwell on this.
Post-it.
Okay.
I feel like we might punt it not just to next month, but to we have a lot of contentious issues that we're kind of punting to until the end. I suggest we punt this to the end, because we can otherwise we're going to just revisit the issue for all of these other conversions.
Right. I want us to look at them in totality, right? When we understand the complete impact of, because I see value in both of these perspectives. And I think we made a policy decision to go with ROLCA long ago, except to the extent it doesn't make sense. And I think this may be one of those areas where the committee decides that it doesn't make sense. But I want us to have the weight of, okay, here in all of these circumstances. So that's why I have a Post-it. So we'll address the Post-it when we get farther down the road.
Okay, Valerie, I just want to say I think that's a really good idea, in particular because how the fiduciary duty question turns out may well affect how people feel about this.
Well, that's a very good point. I'll make another Post-it.
Okay, so we just discussed A1 of 1023. Moving on to A2, for which I don't believe there is any ORS analog provision. A2 deals with a highly unlikely situation where the surviving entity to the merger is a general partnership, in which the owners would have personal liability for that entity following the merger, or a limited partnership where one or more of the owners of the surviving entity would be a general partner having personal liability for the obligations of the surviving entity. And essentially what A2 says in that highly unlikely scenario is that if someone's going to have personal liability for the surviving entity post-merger, they need to specifically consent to the merger. Now it's more complex than that, but that's the basic issue, is that in a scenario where a Oregon LLC in this situation would be a party to a merger in which the surviving entity would be a general partnership or a limited partnership in which some of the members of the LLC would become general partners and therefore would have personal liability for the obligations of the business, they need to consent to it.
Would this apply to a guarantee? That was the scenario I was thinking. What if you guarantee the LLC's debt?
Okay, I haven't thought about that scenario, so let me read it more carefully. Is the exact same provision, Jeff, in the conversion? Yeah, okay.
Yes.
What's the answer?
No, I personally I don't have an answer other than just my interpretation, and it would apply to a guarantee as well, because you would have liability for the debt of the LLC on a guarantee.
Yeah, but a guarantee is a separate transaction than a merger itself. I suppose so for example, you know, you don't just by virtue of a merger become a guarantor of the obligations of the surviving business.
No.
Unless it's a general partnership or a limited partnership in which you're a general partner.
Well, we'll take the situation where LLC enters into a loan, it's guaranteed by the members, then a subsequent merger. That's the scenario I'm thinking, because this talks about, you know, unless A is, you know, it has to do with debts before or liabilities before, not after the merger.
Jeff, I think the answer is in the definition of interest holder liability, because section A2 says by each member of a domestic LLC, which will have interest holder liability. And if you go back to the definition of interest holder liability on page 180, it's liability that is imposed solely by reason of the person's status as an interest holder. So I would take that to mean that if your liability was imposed by virtue of a guarantee, it would not be affected by this section. And I suspect that's the reason this was written that way.
Yeah, I agree. Thank you for reminding me of that, Teresa.
Does this have any interaction with the distribution rules? Distributions on liquidation. I mean, it's not really a liquidation, but I just wonder that because there is some liability in what was that? 40. Sorry, I have it 405, I think. But that has to do with are there distributions on a liquidation, which I don't know if this has any implications.
I don't think it does, Roberta. What the official comments to A2 say is that what this is contemplating is the scenarios I described, where the surviving entity is a general partnership or limited partnership or other type of entity in which it's possible for an owner of the entity to be personally liable for the obligations of the entity due to the nature of the entity. I think just to provide my opinions, this is a very low stakes provision because I think it'll seldom, if ever, arise, and it makes intuitive sense, and I don't think it's supposed to be a gotcha provision, and so I don't have any trouble with it.
Well, two thoughts. One, I now looking at the definition, I agree with Teresa. It doesn't cover personal liability. The definition of interest holder liability does not apply to guarantees. Where I would a little bit disagree with you, Mohsen, is that when you're merging partnerships, you know, and these days partnerships are going away and people are getting rid of them, although lots of times they're through conversion, but you've got the same rules in conversion. But the idea is, why would you want to be a limited partner or general partner with liability when you could be an LLC with no liability? And so you see a lot of these things, a lot of them are flushed out, but you see a lot of mergers and conversions to get rid of the partnership structure. And in that case, it's always going to apply.
No. So this applies in the opposite scenario where the surviving entity is a partnership. So if an Oregon LLC merges with a general partnership and the surviving entity is the general partnership, and the members will now become owners of a general partnership and will have personal liability due to the vicarious liability the general partnerships create for their general partners, then the consent of those members is required because those members will become personally liable going forward following the merger.
Okay, well, that's good because you almost never see those happen.
Exactly. This is a situation that's highly unusual.
Right, okay.
It's kind of a belt and suspenders extraordinary situation. The one situation where I could see this arising is an LLC becomes party to a merger in which the surviving entity is a limited partnership, in which one or more of the LLC's members will become general partners of that limited partnership. But again, that's a highly unusual scenario to have a natural person be a natural person and not a limited liability entity to be the general partner of a limited partnership. So I could make a case for just omitting this as needless complexity because I don't know when this would ever happen. But at the same time, I see the policy behind it, and sure, it could happen. So maybe we should include
I agree.
Any further discussion or concerns about this provision?
And it's in all of them, I think, isn't it? Right?
I'm sorry. Go ahead. What was that code?
1023A2 is in, it's 1033A2 and 1043A2 and 1053A2, and it's non-waivable under ROLCA.
Right. That's a good point too. It is. Is it unwaivable?
Correct. It's 105C14, I think.
Thank you for pointing out. This is an unwaivable provision, although I quibble with that because what A2A says is unless the operating agreement provides in a record that approval of a merger in which some of the members may become subject to interest holder liability by affirmative vote or consent of fewer than all members. So the operating agreement could specifically address the situation and say that unanimous consent is not required, or the consent of those members who might be personally liable is not required. But the operating agreement needs to specifically say that, call that out, which I think is fair enough. But again, this is such a highly unusual situation that this would happen that it almost astonishes me that they felt the need to include this in the statute.
So my understanding is that we're all just fine with A2 as written.
Yeah.
That's my understanding and recommendation, unless anyone has objections. And again, this is all subject to us having to go back through the definition section with a fine-tooth comb.
Right.
Sure
Yeah, and that makes sense. I mean, I think for purposes of our discussion now, we're sort of putting pins and things about how we feel about them, and then we'll go back and evaluate.
Okay. So that completes 1023A, which brings us to 1023B and C, which I think we can consider together. Both these, I think, are relatively uncontroversial. They're analog. There's an analog provision in ORS 63487-1B. What both of these provisions essentially say is that if the entity involved in the merger is not a domestic organ LLC, then the plan of merger needs to be approved by whatever organic law governs that other entity. So it just says, and of course, the other entities of the merger need to approve the merger pursuant to whatever organic law governs them.
Makes sense.
Any questions, concerns, or issues with either of those?
Would now be a good time to take a break? We're a little bit early, but oh, Roberta read my mind.
No, not reading your mind, reading more other things.
Why don't we take a 15-minute break, or why don't we take a 10-minute break, and we'll come back at right around 10:30.
I just started the recording again. We're good.
Okay, great. So I have us at now 10:24, which deals with a plan of merger that has been approved, but that the parties wish to subsequently amend or abandon. The analog provision in ORS is 63487 subsection 2, which authorizes the abandonment of a plan of merger, but does not contemplate an amendment to a plan of merger. So the amendment concept would be new to our law. The abandonment concept is something that's already in our law. I'll note at the outset that that this provision is modeled closely on the language that's set forth in the Model Business Corporation Act. And so to the extent we care about uniformity in corporate statutes, this provision is drafted to be uniform with those. Okay, so subsections A and B of 1024 deal with the process by which a plan of merger may be amended. And so we'll look at those first, and the subsections C and D deal with the process by which a plan of merger may be abandoned. So with respect to A and B, what subsection A says is that a plan of merger may be amended only by the consent of both parties to, or all parties to the plan of merger, which makes sense, right? To the extent the merger is a consensual transaction, and there's going to be any change to the nature of that transaction, both parties to the transaction, or all parties to the transaction ought to consent to that change. So I don't see A as controversial, even though it's new. Any questions about that? Okay, subsection B describes how a domestic organ LLC may go about approving any amendment to a plan of merger. And B1 says that unless the plan of merger provides otherwise, any amendment to the plan must be approved in the same manner the plan of merger must be approved under the RU LLCA. So essentially, whatever kind of member consent was required to approve the plan of merger in the first place would be required to approve any amendment to the plan of merger. That makes sense, and I don't have any problems with it. Any questions about that? Note that right this language seems to assume that the plan of merger could provide otherwise, that that the plan of merger could require some different threshold of consent or some different mechanism of consent required to amend the plan of merger. But in the absence of that kind of language, whatever was required to approve the plan of merger in the first place would be required of the domestic organ LLC to amend the plan of merger. Subsection B2 says that if the plan of merger sets forth a mechanism for approval of any amendment, then there's at least a mandatory rule that members of a domestic organ LLC are entitled to vote or consent on any amendment that would have any of the following effects on the plan of merger. So if the amendment were to change the amount or kind of merger consideration involved, would change the articles of organization or operating agreement of the surviving entity, or would otherwise materially adversely affect the member with respect to the merger, then that member has a right to vote or consent to that change. This again makes sense to me. What they're trying to protect, changing the rules or the terms of the merger in a way that would materially alter it, and is consistent with MBCA. So I'm generally in favor of this.
Anyone concerned? Okay.
Jeff, you see the same rules in conversion?
Yes, with one exception. Conversion doesn't have A. It starts with conversion starts with the merger B. Interesting
right.
enough.
That's because conversion is a single party transaction, right?
Right.
Yeah. So you don't have multiple parties that need to consent to the conversion. Okay. So we're fine with A and B, which adds this concept of amending a plan of merger that's already been approved by the members. Okay, then I'll move on to C and D. Here, this deals with the mechanism by which a plan of merger may be abandoned altogether. As I said, there is an analog provision that deals with the concept of abandonment of a plan of merger under ORS 63487 subsection 2. So looking at ROCLA, this is subsection C, it essentially says that a plan of merger may describe what the mechanism would be for abandoning that plan, and if it provides for a mechanism for abandoning that plan, that's the mechanism that would need to be complied with to abandon the plan of merger. And then, in addition, the second sentence says that unless the plan prohibits it, a domestic organ LLC may abandon a plan of merger in the same manner that it was required to approve the plan of merger. So whatever process or consent was required to approve the plan of merger would be required of an organ LLC to abandon that plan of merger. Note that this is slightly different than what's currently in the ORS. In ORS section 63.487, 2A, 2A provides that a organ LLC may, without the action of its members, and in accordance with the procedure set forth in the plan of merger, or if there's no procedure set forth in the plan of merger, in a manner determined by its managers, abandon the plan of merger. So essentially, the default rule under ORS is the managers can abandon a plan of merger, and ROCLA subsection 1024C contemplates something different, which is that whatever mechanism was required to approve the plan of merger would be required to abandon the plan of merger. To be frank, the ORS provision doesn't make a whole lot of sense why it should be left into the hands of the managers. The roll club provision seems to make a lot more sense. I would support adopting the roll call provision, but I would also tee up the question for the transactional attorneys. How often do you see your plans of mergers abandoned?
I mean, it happens, but you know,
Well,
I've never used this manager provision, so.
Well, and where it might happen is in the context of a merger in lieu of a sale. I mean, I've seen it once or twice fall apart in that context, and I'm sure James has as well. But when it's in the family, like, you know, two related entities merging, never. But
okay, so
yeah.
this provision could get used.
Yeah,
Yes.
and I like the parallelism with the adoption provision better, frankly. I think it's clearly laid out sort of what the process is in ROLCA. And I look at 623, 487, and it's just not quite as specific.
Yeah, I agree. If this is important, the ROLCA statute is much better in terms of drafting and clarity than what's in ORS. And so I would support adopting C. Any further discussion on C?
James, I think James has something to say.
Go ahead, but there's
I was just going to say, oh, go ahead, Jeff, sorry.
Well, there's additional language. If you look at the end of 2, right before A, it says subject to any contractual rights. There's no equivalent there in C.
No. So I read that so C says that after a plan of merger has been approved, but before a statement of merger becomes effective, the plan may be abandoned as provided in the plan. So the plan is lays out the contractual rights that the parties have to abandon the merger.
Does anybody have any color on subject to any contractual rights? So I mean, you read that. I didn't necessarily read that, Mohsen, as the plan itself, which is a contract, but other contractual rights. I'm not really quite sure what that goes to, but I wanted to highlight it because it's there in the ORS and we don't have the equivalent in ROLCA. I mean, James, do you have any idea what that language is referring to?
I can't find it. Where are you looking?
Right before A. So read subsection 2 of ORS. So we're
ORS 63-487, subsection 2. The introductory paragraph has this proviso subject to any contractual rights. So what I read that, Jeff, to mean is that an agreement and plan of merger will have provisions pursuant to which the agreement may be terminated and the plan may be abandoned. And that's essentially recognizing that this rule is subject to the freedom of contract, and the parties can specify how the merger can be abandoned. And if they do, that governs. And if they don't, then this is the default rule. I read subsection C of 1024 to essentially be the same thing, which is that the plan may specify how it may be abandoned. And unless prohibited, here's how a domestic organ LLC may be.
Okay. So really that should say in ORS, subject to the terms of the plan, as opposed to subject to any contractual rights, because that's confusing and very broad, but you're saying it's really subject to the terms of the plan. These are the default rules, A or B.
Yeah, I suppose there could be a side contract, right? It's not the plan of merger itself.
And that's typically what we do. I mean, we'll have a 2-page plan and agreement of merger that frankly often we'll file even though we don't have to. And then we have a 60-page merger agreement that the buyer actually signs. And that's what I was reading contractual rights to affect. You know, your sellers can decide they want to abandon it under the document that gets filed, the short one. You may well get sued by the buyer if all their closing conditions were satisfied. And that's, I think, what that's trying to pick up.
So that's why it's broader in your scenario, James, the contractual rights, because it may not be limited to the plan, but a document related to the plan.
That makes sense if you've taken actions in reliance, right? I mean, you've done all these things.
But does that need to be?
I don't think there's.
I'm sorry. Does that need to be in this statute though? Because if the buyer has a contractual right, that's really not is that necessarily part of this plan of merger? I think what I heard you said was it's not. So the buyer will still have their contractual rights even if we adopt this. It doesn't take those away.
So you're referring to at the end of subsection C, first sentence, as provided in the plan is not broad enough. Because what James described is it's other contracts as well, you know, like an agreement of merger.
Yeah,
Well-
but what I'm saying is that, does that have to be in the LLC statute? Because that's a contractual right that is kind of outside of this merger, isn't it?
So James, I'll confess I haven't done a merger on Oregon with an Oregon entity, but now that I've looked at closely at the statute, I recognize that the reason you're doing your transactions like that is because you have to make available the plan of merger either by filing it or saying where one can find it. And so you want to have a separate agreement that doesn't include all the stuff that you have to make public. The RULCLA does away with that. You'll file a statement of merger that is the bare bones document that you're used to filing anyhow. And so the statement of merger is the document that gets filed. The plan of merger will, I think, wind up just being the merger agreement.
I don't think we have to disclose the bigger agreement now. I don't think we have to.
No,
I
you have
think
to
say
disclose
that
a
it's
plan of,
available to members.
but
I'm working off, not looking at the statute at the moment, but
yeah, but so anyway, I think this gets to Roberta's point though, that the plan of merger is going to be the meaty document, but that doesn't get filed and that doesn't become a public record. And so I think that's going to set forth that plan of merger is going to be called a agreement and plan of merger, and it's going to have all the terms and conditions of the merger, including the mechanism by which, if any, the merger can be terminated or the plan can be terminated.
Yeah, I think, but even if that isn't the case, even if you do end up having a significant separate side contract that governs the terms of the agreement, I don't think there's anything in ROLCA that says just because you abandon the merger, you get a get out of jail free card for the breach of contract lawsuit you're going to get for that separate side agreement. There's no exoneration from the other obligations. And I think that's what Roberta's point really was.
Yes, it was. Thank you.
ROLCA's job is not to create a get out of free card, and it doesn't create a get out of problems free card. It just says you can abandon the merger, but you're still stuck, I think, with whatever consequences you have from a breach of a separate contract action to not complete the merger.
Right, but I do think it makes sense to have something about this in the LLC statutes. I mean, I think that was my concern about what Roberta raised, was that, you know, we can't just wholesale take it out. I mean, I think we need to talk about the process in the LLC statutes to the extent.
Right. I mean, you're separating the process of how we just don't go forward and decide to abandon the merger from the contractual consequences of that decision, which may be governed by some other document or some other law. And I agree, we have to say something about the fact you can abandon one, but I think it's okay that ROLCA is silent on the question of what are the consequences for making that decision.
Yeah, I agree.
So I'm not sure where that lands us on C, whether that requires any alteration of C. I don't think it does, but I allow.
I don't think so, because there's other stuff that could be implicated. So.
Okay. So that brings us to D. D deals with the scenario where an LLC wishes to abandon a plan of merger after it's already filed the requisite paperwork with the Secretary of State to make the merger effective, but before that paperwork itself becomes effective. So the merger hasn't become effective because the paperwork, what's called a statement of merger, has a later effective time. And so if the LLC has filed the paperwork, but now wishes to abandon the plan of merger before the merger becomes effective, D creates a mechanism by which the LLC can do that by filing a statement of abandonment with the Secretary of State. There is no analog to this under the ORS. I'm not opposed to this, although I'll note that this would create a new filing for the Secretary of State to accept.
there is something in current Oregon law to rescind or otherwise withdraw something that's been filed with a later effective date, I think.
Okay.
Looks like
It maybe is a more general provision.
a lot of
It's
times what if someone decides that they don't want a filing to happen, then they would withdraw under ORS 56080, and then that would give them the opportunity to go ahead and withdraw the filing. So I'm not sure if that would go along with this or if it would be a completely new filing type.
So I think we need to look at that provision, which I'll pull up to see if that covers what needs to happen here. What was the section again?
It's
50
ORS 56080.
Zero. Thank you.
But ROCA does have the specific document, statement of abandonment, which I think is a defined term.
Right. That's what ROCA would contemplate is required to effectively withdraw that statement or that plan of merger before it becomes effective. And the question is whether 56.8080 already allows an entity to do that with the Secretary of State.
So the question would be, would we change the language in ROCA to refer to that section as and take out the concept of statement of abandonment?
I mean, we have a whole list of statements in the definition section. You know, what is it? Section 1001, sub 33 through 36, and you know, abandonment's not on there, but it certainly probably should be.
Well, I'm going back to section 102. Is it there?
Sorry to interrupt. I think we should keep the ROCA provision. As I'm looking at 080 in chapter 56, it appears to be discretionary. It looks, I see may, whereas this would put it in the party's control.
Mm-hmm.
Yeah.
Oddly, it doesn't appear to be a definition of statement of abandonment
Right.
in 102 or 1001.
No, I know, and which is weird.
Yeah. Because
it seems like 56080 is limited to situations where the filer says that it was submitted prematurely or by mistake, whereas I think here we're contemplating everybody intended to file it and then they just changed their minds.
They did file it and then they changed their minds before it became effective. Yeah.
Well, and I'll point out that,
but it wasn't a mistake or it wasn't premature. It was just they changed their minds. So I think it's broader than 56.080, but it may be something where we want to, for reasons of not creating an economic impact on the Secretary of State's office, maybe what we want to do is point to 56.080 and somehow expand that so that it would cover intentional withdrawal or abandonment of a document. Because I don't want to create an economic impact inadvertently if there's a way to work with the existing statute to avoid that.
The other approach is to omit this section altogether, and essentially the law would be then that once you file the requisite paperwork, you can't take it back, right? So that would be the point in time which you can't abandon the plan of merger. That's similar to, let's see, I think ORS as it exists, because what ORS says now under 63487 subsection 2 is at any time before the articles are filed, the merger may be abandoned, the plan may be abandoned, right? So filing is kind of the drop dead point by which you can abandon. And if we just omitted this subsection D altogether, that would be consistent with what we have under ORS. I'll add to that I think it's relatively infrequent, if ever, that you get to the point where you file the requisite paperwork, but then the plan of merger gets abandoned.
Well, I am not going to agree with that approach, because what you're doing then is you're taking away the ability to have a future effective date for the merger. This is identical in conversion. I bet you it's identical in domestication. So we have these articles of abandonment in multiple areas. And I don't like the idea of taking away the future effective date. So it's like what James was talking about. Sometimes big mergers involve effectively a sale with conditions precedents to closing. And they said they filed the articles of merger to get the process going, and then with a future effective date. And then if conditions are not satisfied, they want to abandon the transaction. And you're like eliminating all of that if you take this out.
why would you file the paperwork before the closing conditions are satisfied? Before you're ready to close?
Now you're describing my practice. That's why I rack up all these last minute filing fees and expedite fees.
Go ahead, James. Go ahead. Explain.
No, I mean, it is preferable if you can file ahead of time. And in particular, the main time when I file ahead of time is when I need an effective date that's a month end that happens to fall on the weekend. That's my most practical time.
Okay.
And I really do need an earlier filing, but then I'm filing it on Friday and I can't file a withdrawal on Saturday morning anyway, because no one's there to take it.
I just want to know, Jamie did put in the chat that this would cause additional expense for Secretary of State, which was mentioned, but she put an approximate cost.
Again, then we have to look at this from the fact that we're looking at 3 or 4 different areas where this articles of abandonment are going to apply: domestication, conversion, merger, this exchange thing. I think it's in all of them.
Well,
Yeah.
and that's why I think maybe the solution is to somehow amend ORS 56.080 to become broad enough that it could create an opportunity for withdrawal for something beyond inadvertence or neglect, because that may not require a new process. Maybe it requires a little bit of an amendment to a form, and I don't know if that's as much of a problem. That's a question for Jamie.
Is there an issue with doing that because it's outside of this act? So now we're looking to touch a different, to make this act work, we're looking at touching a different ORS section. Is that problematic?
Well, I mean,
I worry that opens up a can of worms.
I mean, we did talk with Sean a little bit about that, because part of the job of Legislative Counsel's office is to see if there are these carry-on effects of involving other sections.
Because you could easily, I think, amend 56080 subsection 2, where it says that the document was submitted prematurely or by an inadvertence or mistake, and it would be change that to document was submitted prematurely by inadvertence or mistake or needs to be abandoned. I mean, I don't know if that has an economic impact or is a material problem for changes to ORS 56.080, but it would certainly solve this problem.
Are we worried about the financial impact on the parties or the financial impact on the state?
State.
The state.
State,
Yeah,
because that's what makes it hard to pass a bill.
Exactly.
But can't the state provide for a fee will apply? I mean, I don't know if that needs to be in the statute or not, but I mean, if it's going to cost, then yeah, you can abandon your plan, but you're going to have to file new forms and it's going to cost you.
Yeah, and we've already, I mean, I think that it's worth noting that there may be some new forms that come out of this, because we've already talked about, for example, the certificate of authority. But that's core to what this project is that there's going to be some changes there. So I don't think we're going to get completely revenue neutral without, as you say, imposing some sort of fee or offset, or authorizing some sort of fee or offset there for filing.
Yeah. And do you think that needs to be in this statute, that the fee is authorized, or?
Well, I think that there may need to be some language baked into the original bill, right? Because I don't know that, I mean, because that would probably involve, and Jamie can probably talk to this more accurately, but that would probably involve the enabling statutes for Secretary of State, or at least addressing the rules the Secretary of State has as a follow-on to this. Where such things are specifically scheduled out. So I'm not totally imposed. Yeah, and I agree with James's comment in the chat that, there's going to be some new forms that are involved. And I think what our role right now is to figure out what the best answer is, and then maybe keep a list of where we think that there are these issues, and then we can talk about, and we can work with Legislative Counsel and Susan and John, because that's going to be a how do we get this bill passed question, right? More than a is it the right thing to do question.
I think that once we know a little bit better of how many transactions and how many new forms, which we probably will have a lot of new forms, but then I can get our group together and we can get just a general fiscal impact, and we can be able to have a little bit better understanding of how it will work out. But I do think that because we'll be doing more than just one, it would
Yeah, and that's one reason why it's so valuable to have your office involved, Jamie, is you know, you can start thinking about, okay, well, this is going to be totally unfeasible, or you know, we can start laying the groundwork for figuring out how do we get you the tools in our bill to get what you need. Bye, Kyle.
So James, you said the situation where you would file a plan of merger, but with a later effective date, is when you need the merger to be effective on a weekend, right? Well, even under this scenario, right? Let's say you file a plan of merger or statement of merger to become effective on a weekend, but you wish to abandon it. There's not going to be anyone there on the weekend to take your filing of abandonment anyway, right? So again, I come back to the position. I just think this might be unnecessary because unless the transactional attorneys feel like they really need this additional flexibility, the practice, I assume, had been that you just wait until you're ready to close, and that's when you file the plan of merger.
That's right. I don't feel strongly. I mean, it's sort of a nice to have. It'd be great to check one more box off my list before the last day, but knowing me, I end up doing all the boxes in the last day anyway. So
what's M&A practice without, you know, a big closing day, right?
Yeah, it's not, this is not a big issue for me.
So my vote would be to omit it altogether, but that's my vote.
Section D entirely?
Yes.
But then is that, are we also eliminating the ability to set a future effective date, or just the ability to abandon after you file regardless of a future effective date?
I think we're not eliminating the ability to set a future effective date. I would not support that.
Okay.
But you just can't abandon it once you file it.
Right.
Does that cause you any heartburn, James?
No, I'll do it at the end.
You'll do it on the day you're ready to close, yeah.
All right. So
Okay.
I'm gonna cross through sub D unless people feel strongly we should keep it.
And I suppose we can come back and revisit this as we talk about the other transactions where this concept is similarly incorporated, but I don't see an obvious reason why it wouldn't be the same.
All right, I'll cross through it in
Conclusion.
pencil.
Yeah.
Well, and I think in the case of conversion, I can say it'll be the same decision, because it's the same type of issue. It's just a future effective date. You know, really a month in, you know, makes sense.
Okay. Okay, so that brings us to 1025 of ROCA. This deals with how to make a merger effective, and it requires the filing of paperwork with the Secretary of State. The analog provision is set forth in ORS 63.494. Okay, so 63.494 already requires the filing of articles of merger with the Secretary of State to make a merger effective. ROCA 1025A requires similarly a filing of what's called a statement of merger, whether we want to retain that language or just refer to it as an articles of merger, doesn't matter to me. What's required to be included in the statement of merger is slightly more similar, but just slightly more than what's already required under the ORS. I'll note a couple of things. One is that under the ORS, that either the plan of merger has to be itself filed alongside the articles of merger, or there needs to be notice of where a member can get a copy of the plan of merger. Under WOLCA, there's no such requirement. All that's required is that a statement of merger containing this bare bones information is filed. So that's one difference. I can pause there to stop to have discussion of that, or I can go on to the other differences. The other differences are that under B4 of 1025, This is again a situation where ROLCA expressly contemplates the consolidation scenario where two entities would merge and the resulting entity would be, the surviving entity would be a wholly new entity and not one of the constituents to the merger. Oh, sorry, that's B5. B4 deals with the situation where one of these constituent entities survives the merger. So one of the constituent entities survives the merger, kind of the more normal merger scenario. In that case, if the entity surviving entity exists before the merger and is a domestic filing entity, any amendment to its public organic record approved as part of the plan of merger must be included in the filing. So any amendments to its articles of organization must be included in the filing. However, any amendment to its operating agreement need not be included in the filing. So that I don't see that as particularly controversial, because to the extent the articles of organization is already a public document, any amendments to that public document should be included in the public record as well. What A or B5 provides is the consolidation scenario that I jumped ahead to earlier, which is that if two constituents to the merger form a new surviving entity, then that new surviving entity's formation document must be attached to the to the statement of merger. And what the comments provide is that attaching that document to the statement of merger has the effect of bringing that entity into creation. You don't need to separately file the formation document to bring that new entity into formation or into existence. The attachment of it to the statement of merger is what creates that entity as a result of the merger. So let me just pause there. That was a few things. Are there any concerns or questions about any of that, or objections to any of that?
Well, the one thought I had is the Secretary of State picking up out of 5 that essentially a new entity is, you've got this statement of merger filed, but in it is a certificate of organization. And will the Secretary of State needs to be on top of catching that and actually creating a separate entity with all the website information and what have you. So it is a new paradigm, sort of.
It's not that you can just create a new LLC. You can create a new corporation, or any kind of entity can be created as the surviving entity of a merger. I'll come back to a point I made at the very beginning, which is our statute seems to contemplate the consolidation scenario already in a merger transaction, but it only just says that that's a possibility, but doesn't contemplate how that happens. And so how the new entity gets formed under the current statute is left unsaid. Here, it's being explicit that the new entity gets formed by attaching the formation document to the statement of merger.
Yeah, and my feeling on this is that it would show up at Secretary of State's office as a packet of stuff, right? And so you would have your separate filing fee for the new organizational document.
See, I would see this as you have the statement of merger and then an attachment.
Right.
Because it's got to be part of the statement.
But it's all going to be a packet, right? And Jamie, if there's a way that we can flag it better for your office, I'd love to hear it.
No, I think this makes sense. What we'd probably end up having to do is just file the new filing and then file the merger on top of it. And then, but we would probably at that point need to just keep it like, basically we're pretending that it's one transaction. We do it with conversions right now. If there's a foreign that is converting in as a domestic, then we go in and we basically like fake a new filing, and then on top of it we file the conversion and kind of have it all as one. So that definitely makes sense to me.
Okay. Okay, so that was
really quick from my record keeping. What was the analogous ORS to 1025? I just missed that at the beginning.
It's 63494, 63.494.
Thanks.
I was just curious. I'm sorry for not catching what our decision on this was, but the part of the current statute 494 about how you have to file the plan or the statement that you've got a copy of the plan, that was added to our statute in 2015.
right.
And so it's, to me, it just raises the question, is that normally when that has been the case, when it's a recent change to Oregon statute, we've been including that in our version of ROLCA. And I was wondering whether we should add either that identical language or, similar ROLCA-ized, terminology as section 1025B7.
I'm in favor of keeping the where they can give us the plan or just give us the address where it's located. It is something that's more recent for us, and it's made life a lot easier. So we would have a lot of staff that would be pretty upset if they couldn't have that as part of it at this point.
So I'll add that
494 1B language.
That's what I was thinking.
And then include that as sub 7. I think that's reasonable. And I agree with you that it looks like it's oriented towards greater transparency and information sharing.
So one section we haven't gotten to under 1025 is subsection E, which does provide that the plan of merger may be filed instead of a statement of merger. So in lieu of a statement of merger, you could file the plan of merger, but that's optional and it doesn't require filing in the way that ORS currently does, filing
Right.
or availability.
The concern is having a point of contact, right, Jamie?
Yes, that is my understanding too.
Yeah, which may or may not be in the other documents. So I think it's fine. I support adding that as a sub 7 just because it doesn't cost anything. Okay.
I'd be interested in Jeff and James's thoughts on that.
It needs to be limited. I mean, current Oregon law is limited in terms of with whom you have to share it.
Sure.
That would be my main concern. And I'm struggling to think of a scenario where we're not sharing the whole agreement with anybody within the entity anyway. If any member or manager or owner asks a question, of course they're going to see a copy. We're probably going to be sending them 10 copies by the time it's all done. So
they're probably signing it too.
Yeah, given
constituent entity or parties too are signing.
I think what we're talking about is that language about what you file as Secretary of State, right? Under 63 494 1B.
My opinion is I don't have a problem adding it as long as you're not required to file the plan. I mean, because for the most part,
that's inherent in it. That's part of the copy and paste from the Oregon statute.
Yeah, it's already in there. And
right. So the only reason I would agree to do it is because it was added for some policy reason in 2015. I'm curious to what the policy reason was, but so in that sense, I'm okay. Just to again, we don't want to deviate from policy.
So to recapitulate, then the consensus is that under 1025, we should add the requirement, the same filing requirement that is currently set forth in ORS 63 494 1B. And then I think what that means is that subsection E of 1025 comes out altogether, because 1025E essentially creates an option, but not an obligation to, I guess it could stay in, but I had to think about the ramifications.
Yeah, I don't think I think it's addressing a different issue, right?
I mean, I think that they can both be in there. Obviously, if you choose to file the plan, then you, as E says, the plan itself has to contain everything else that B requires. And because you are filing the plan, you're also going to be complying with this 494 1B requirement. But if you choose not to file the plan, the fact that you don't file it is, that's okay, both under 494 1B. It's also okay under E.
Yeah, because it's permissive language, right? In that both sections. So I think.
And what I was thinking about that actually is does it make more sense rather than putting the statement about you can just file the address where you can find it in 7, rather putting it in E. So maybe have an E1 and E2, because those are both sort of permissive and talking about filing. So,
no, I think
that's right, because because this, you're only going to do this, you're only going to make the plan available if you're filing the statement,
Right.
right? If you're doing the statement, that's the short version that gets filed. You're saying we're also going to make this available to you, members and shareholders. Or under E, you can file the whole darn thing if you want to, but you're going to annoy Jamie.
I'm not going to annoy Jamie, so I won't be.
Don't annoy Jamie. That's our number one rule.
Please don't.
Any further discussion on that?
So we're going to add this as a subsection 7 to B, right?
Yep.
Yeah, I think that's where we came out.
Yeah, yeah. And again, it carries out the policy decision that was made in 2015.
Yeah, and to the extent it provides an additional point of contact for Secretary of State, I think it reflects the trend that we've seen in Oregon law towards additional transparency. So I think that's worth keeping.
One section that we haven't talked about yet is 1025B6, which comes back to the concept of what if the surviving entity from a merger is a limited liability partnership. Then, so again, we're talking about a consolidation scenario where two entities merge and the resulting entity is, the surviving entity is not one of the constituents to a merger, but a new entity. And that new entity is a domestic limited liability partnership, then a statement of qualification needs to be attached. I'll confess I didn't look up what a statement of qualification is as it relates to an LLP, but maybe someone on this call knows what that is and whether that's relevant to our law. Stated differently, under existing Oregon law, do LLPs need to file statements of qualifications, and if so, what do they do? I can put this on my homework
I forget
list.
the name of it. But isn't the general concept that a partnership can exist under common law without any filing?
Yeah.
And if you want the LL as part of your
You have to file
existence, then you
That's
file
right.
you file something, whatever it is, you file something. I'm guessing
And
that's what this is.
Okay, let me, I think that's right, James, thanks for refreshing my memory. Let me double check that, but assuming that's that's just simply the formation document. Although that raises the question, then why isn't that already covered under 5, subsection 5?
It's the
Maybe-
distinction between formation and getting the LL attached to something that's already formed.
Yeah,
I think.
agree.
Yeah.
Or,
Jamie,
you
do
know,
you know off the top of your head what that's called?
well, I was going to add just annual report too.
Jamie, do you know what that's called off the top of your head?
I do not off the top of my head.
Yeah, no, that's fine. I mean, we can just flag it for legislative council.
I'm just pulling it up right now. I think it might be called an application for registration.
It's, oh, you know what? Actually, I can probably, let me get to this other screen here. Certificate. Let me find it.
Certificate of limited liability.
I think something like that.
Yeah.
I'm in the office today. I'm better at working remotely right now.
It's gonna be an adjustment for all of us, I think. Especially my dogs.
So LLP.
There is something in ROLCA on page 186. Now that doesn't exactly answer the question of whether it's, where is it in ORS, but it says a statement of, this is a it's under the comments under filing entity. And it says, while a filed document is a precondition to LLP status, that document, a statement of qualification under UPA, section 901, does not form the underlying entity.
Right, and that's what James was getting to, is the liability issue. I mean, I think it's the certificate of limited partnership.
Have application for registration.
It's application for registration.
Limited liability partnership.
And a triple LP is a filing entity, but I guess we don't have triple LPs.
Yeah, I don't think we have those.
We don't.
So I think the upshot is then simply the statement of qualification needs to be changed to application for registration.
That sounds right.
And this,
And if
this
anybody
deals with
wants the site, it's 67.603.
I always love sites. Thank you, James.
and this deals again with the highly unusual scenario where you have a LLC that is a constituent to a merger where the merger is actually a consolidation where the surviving entity that will be created is a limited partnership or limited liability partnership, I should say. I guess maybe law firms might do something like this.
I'm confused. Again, doesn't 5 cover that?
No,
5
because the note that Roberta points us to, page 186, this gets into, I think, pretty minutia, but the term filing entity is defined in a way that doesn't include an LLP, because while a filed document is a precondition to LLP status, that document, a statement of qualification under the Uniform Act or a statement or application for registration under our statute, it does not form the underlying entity. So the underlying entity, the partnership, is created through an association of 2 or more persons carrying on business for profit. But to get that status of limited liability partnership requires the application, or whatever it's called under our law, the application for registration. So that's not actually, that application is not creating the entity; it's just creating limited liability for the entity. And
well,
that's why
it's, in other words, it's converting an existing GP into an LLP.
Right.
Okay.
Yeah. So we have
And
to have
yes, it's in the weeds, but you know, we are in the weeds.
we are very much in the weeds. Okay, so I think that takes care of subsection 6, as long as the language is changed to application for registration. Okay, so I think that brings us to, okay, this is 1025 subsection F, which is essentially provides when the statement of merger, the public filing, when the merger actually becomes effective. And it says for a domestic LLC, the merger becomes effective when the statement of merger is effective. The statement of merger becomes effective pursuant to 207 of RUCLA. So under 207 of RUCLA, my recollection is that essentially it becomes effective on filing, on the date of filing, unless a later date is provided, in which case it becomes effective on that later date. Have I got it wrong? Okay, Roberta, you were giving me a very
I was just
quizzical look.
making a face because it just seems that the drafting seems so circular, but
Yeah.
I guess it really isn't, you know, it's effective when it's effective, but that's.
Well, the merger becomes effective when the document becomes effective. When does the document become effective? That's where you have to look to 207.
Maybe, I don't know. Is there a comment in here to say that? Because I would love a cross-reference would be delightful here.
We could include a cross-reference, but then if things get shuffled around in a subsequent amendment, that cross-reference would be stale or have to get updated. I mean, from an M&A perspective, it doesn't seem too crazy to me, but
right.
I
And
recognize
the comment on subsection F is actually pretty clear, even if the section itself is not very clear. Or not as clear maybe as it could be.
the second sentence of F is a little less clear, right? So the first sentence deals with a situation where the surviving entity is a domestic organ LLC. The second sentence deals with every other situation. So every other situation where we have a merger, but the surviving entity is not a domestic organ LLC. And it essentially says that when the surviving entity is something other than an organ LLC, the merger becomes effective on the later of one, the date and time provided by the organic law of the state in which the surviving entity is organized, or when the statement is effective. The first part makes sense to me. The second part makes less sense to me.
And you read it with an or, but it says and, which also doesn't make sense.
I'm sorry, and yeah, you're right.
But it on the later of, it should be, I think or is right. I mean, I don't know. It seems right to me, but who knows? We've been doing this for a while now, and my brain may be dead.
But what if a state doesn't allow future effective dates? I don't know. I'm guessing, because if the state doesn't allow a future effective date, it's effective upon filing. I don't know. Maybe the N works.
No, I agree with Roberta. I think that's got to be a typo.
Yeah, I just don't know how you can have later of and.
Yeah, and anyhow, or is inclusive of and, which is my biggest pet peeve when I see drafting and or.
I think that's something we should flag for legislative council, and they can fix the language.
Yep.
Yeah. I mean, sometimes the and and the or is a big deal, whether you have and or and or. Yeah. I mean, here I just don't even see how it works with an and.
No, I think it's got to be a typo. I don't know what else it could be. But I've got a flag. Okay.
Okay, so are we fine with that change to or?
Yep.
Okay. All right. Any further discussion on that?
No, and actually I'm feeling good about this. We just got the one section left to go in part 2.
Well, we'll see. Okay.
That sounds like a threat motion.
Well, it's the longest section, and I think much of it's uncontroversial, but there's a lot in it.
Okay.
So this brings us to 1026. The analogous provision under ORS is ORS 63497, which covers much of the same ground, but is not quite as exhaustive in what it covers. But I don't think this affects much change. So what this provision does is specify under subsection A what is the consequence of two entities merging. And I think everything under A is consistent with what at least is my understanding of what a merger accomplishes. And so there's nothing under subsection A that I would call out as unusual or controversial or take objection to. It's certainly more than what's set forth in the ORS, but I don't think it changes anything in any obvious way that's already in ORS 63497 subsection 1.
Well, that's a good way to dispose of a page and a half of text.
But I want, especially for the litigators, the creditors' attorneys, right? Because I look at this from a transactional perspective, and all this just seems like, yeah, of course, this is what happens. But I haven't been charged with having to collect from a debtor.
Well, the important thing for me is A4, and it's there, and it seems pretty clear to me.
Right.
Yeah, I actually don't have a problem with almost anything in 1026. I only have a couple nits sort of as we get to the end.
Okay. So subsection B, I think, again, uncontroversial. There's nothing explicit about this, I think, in ORS, but it simply says that essentially that a merger does not give rise to any rights to any interest holder, governor, or third party that they would have upon dissolution, liquidation, or winding up of the merging entity. So a merger is a merger, and it's not a dissolution, liquidation, and winding up.
Right.
Don't we need to fix 9B, statement of qualification? Change that again to, was it application for registration?
Thank you.
What?
And also,
oh, I see.
Motion, what about, there's a reference to appraisal rights in 10.
Okay. Right. So the appraisal rights they have under section 1006 and the Merging Entities Organic Law. What section 1006 provides is that you don't have appraisal rights except to the extent set forth in your operating agreement. Let me pull 1006 in front of me before I paraphrase it. You don't have any appraisal rights except to the extent you set forth in the operating agreement or in the plan of merger. So essentially it's
Got it.
recognizing
Thank
that you could get appraisal rights from some external source, but there's nothing in the statute itself creating that.
Right.
Let me just double check that. Yeah, that's right.
So is this pulling in the minority rights?
Well, what do you mean by minority rights, Jeff?
Well, the appraisal rights.
You don't have appraisal rights by default in a merger. Unless the operating agreement of the LLC affirmatively creates appraisal rights for you, or the plan of merger creates appraisal rights for dissenting members.
Which means you won't have them almost ever.
Right.
Right. I've never seen that.
And I
One
think this
question
is
on-
really
okay.
helpful. I'm sorry, I'm not making a very important point, but I think it's really helpful saying that the merger is not the same thing as a dissolution, right? So that is very consistent with that.
I had a question about, my note on 1006 for appraisal rights was, should we have rights for corporations? Because I thought I had read chapter 60 of ORS to provide such rights for corporations, at least under present Oregon law. And, to the degree that, I don't know whether, if you're merging and there's a corporate entity merging in and it has rights, how is that affected by ROLCA here?
So what ROLCA says is under subsection B that except as otherwise provided in the organic law or organic rules of the merging entity. So if the merging entity is a corporation, then its organic law would be the ORS chapter 60, which would create appraisal rights. But what this says is that unless you're in that scenario, a merger does not give rise to any appraisal rights. Oh, sorry, I'm reading the wrong section. So delete everything I just said.
No, that's right.
But it's the same. Yeah, I was reading the wrong section, but it's the same concept.
Yeah.
And one question I have is, because is there some part of ROLCA that gives you appraisal rights for in an LLC context?
No, I don't think so.
I haven't seen it yet.
I didn't think so either. I was curious why have them for corporations and not for LLCs.
So the answer is that the default rule is unanimity in LLCs, and the default rule in corporations is majority rule. And so to compensate the minority who are getting dragged along by the majority, we give them appraisal rights in corporations. But where unanimity is the default, unless you agree otherwise, then you don't get anything other than what majority rule, or what, you get to consent to a transaction or not consent, and the transaction doesn't get to go forward.
Well, that's interesting. We put a pin in that very issue to discuss later. Right. And if we go to majority, do we have to start talking about adding in appraisal rights?
ORS doesn't currently do that. That's the interesting thing, Jeff, is that ORS doesn't currently do that in its LLC statute, right? We have majority rule for mergers, but then.
But don't we have essentially common law rights, minority rights in LLCs? I've never kind of explored this in the litigators or James. I mean, isn't there still common law, essentially minority rights?
I don't. There's common law claims for breach of fiduciary duty, oppression, that kind of stuff. But I'm not familiar with an inherent common law right to appraisal.
Well, the flip side of
advance of a transaction occurring.
The flip side of the appraisal, of course, is to be bought out. Appraise. I don't like this action. Appraise my interest and buy me out at the appraised price. So it's not just appraisal. What's the purpose of the appraisal? Is to set a purchase price.
Right.
And I do think we have common law rights. And I don't know if it's breach of fiduciary duty or whatever, where again, keep in mind, the whole point of the appraisal is a buyout.
Right. So appraisal. So if you have a fiduciary duty claim, that's one thing. But appraisal rights covers a broader set of situations where you just didn't agree with the majority of your fellow co-owners as to the advisability of a sale, right? Then under corporate law, you have a statutory right to not go along with the sale and seek judicial appraisal for your ownership interest.
Purchase.
Exactly. Right, and that's simply because of a good faith disagreement as to value or advisability. Here, under neither ORS or RUCLA would you have that right. But what RUCLA gives you is the right to say no and prevent the transaction from going forward, because RUCLA requires unanimity as the default rule, whereas ORS requires majority as the default rule, which means if you say no, you might still be forced into the transaction. And again, these are all default rules.
Well, in any event, I feel like the question of whether there should be appraisal rights or dissenter's rights or whatever is appropriately or better addressed when we discuss section 1006 rather than here. And I think that this section 1026 A10 is just fine, because it only says you have the appraisal rights you're given under 1006 or the organic law. And if 1006 gives you nothing, then it gives you nothing essentially. And if it gives you something, then it gives you something. But I just feel like we should have the discussion on whether such rights should exist when we talk about 1006.
And just
right. And I have it on the unanimous versus majority posted.
Right, because it's directly related to that question.
Yeah.
And it comes up in conversions, and I think maybe domestication as well.
Yep, it's on the post-it.
Okay. I'm loving this because the entire conversation of conversion has just been conducted under merger.
Well, they're similar.
I think it's true for all of the 4 types of things they have.
Yep.
Okay.
Yeah, but we'll just go through the details, and then again we'll get back.
No. But we should go through the other sections pretty quickly then.
Okay.
So subsection C essentially deals with the scenario where the surviving party to a merger is a general partnership, and it says that when that's the case, right, then you have personal liability following the merger for the obligations of the surviving entity.
Okay.
That's paraphrasing it, and it's a little bit more nuanced than that, but it's not much more nuanced than that. And it's also a highly atypical scenario that the surviving entity to a merger would be a general partnership or even a limited partnership.
Right.
Which is where this would come up. Okay, any questions, concerns, comments about that? Subsection D deals with the opposite scenario, where one of the constituents to the merger that goes away as a result of the merger is a general partnership. And what it essentially says is that if you had obligations arising prior to the merger due to your status as a general partner of the general partnership, the merger doesn't make those things go away. You don't, right? So a general partnership merges and the surviving entities an LLC, you get limited liability post-merger, but whatever kinds of obligations you had pre-merger continue to exist and don't get extinguished as a result of the merger. I think this is uncontroversial.
This all makes sense, and it's all consistent with the tax code treatment of this too. So
right.
I'm fine with that.
Any discussions or concerns about that?
It makes sense to me from a debtor-creditor context in terms of what creditors would expect if their debtors are conducting these kinds of mergers. You wouldn't want someone to be able to have a merger and have them get out of existing liability, but you would certainly expect them to be able to cut off future liability. So that makes sense to me.
So I'm sorry, I didn't mean to cut you off.
No, that's fine.
You know, and I don't think it forecloses the situation where you contribute, you know, we have an encumbered situation, right? And then you get an assumption of that encumbrance with the consent of the lender, you know, but that is a different situation than what we're talking about here.
Yeah.
One thing that's not in here that is peculiar to ORS is ORS 63497 1H, which has this 12-month tail period of personal liability for partners in a general partnership or LLP that merges into an LLC. So I'm looking at the language in 63497 1H, which says that if prior to the merger, an owner of a business entity was a partner of a partnership or a general partner in an LP and was personally liable for the business entity's liabilities after the merger, and after the merger is an owner of a that is normally protected from personal liability, then such owner shall continue to be personally liable for the business entity's liabilities incurred during the 12 months following the merger. I'd never seen this before, and it's unusual, but it's limited only to the situation if the other party or parties to the transaction reasonably believe the owner would be personally liable and had not received notice of the merger. So it's not as bad as it seems, but it's unusual. I don't know why it's in there. It's not a standard kind of provision in LLC or corporate statutes. So I would be okay with omitting it, but I'm open to other ideas.
Well, I'm curious, so when it says had not received notice of the merger, so does that exclude constructive notice? Because when you file the articles or statement of merger, you've got constructive notice of it immediately.
I assume it would, because then if a constructive notice of that type was sufficient, then this would be, you can't effect a merger without doing that. And so this would have no effect.
Yeah, I'm sure it was intended to get at the situation where you have say a vendor that's selling product to a general partnership, and is expecting that if the general partnership itself doesn't pay, that it can look to the interests of the partners to make that payment. And that's how they have created their financial arrangement. And then all of a sudden, the general partners decide they're going to become an LLC, or they're going to merge, or they're going to do something that creates limited liability. It seems like this is an idea that's intended to protect the vendor that doesn't know about the transaction, that suddenly the liability has been cut off. But typically I would see in those kinds of arrangements something where it would require the counterparty to tell if it changed its entity formation, and that would be a breach of the agreement.
Moreover, this covers general partnerships, but not sole proprietorships, right? Teresa, you could have the same scenario with a sole proprietorship, but this statute, ORS doesn't cover that situation.
Well, it also covers the LPs with a general partner, but and that, let's just point out one obvious thing. The reason 99% of the time, the reason you're converting GPs or LPs to an LLC is to eliminate that liability. I mean, that's the primary purpose of doing it, of merging or converting or what have you. So.
Is this, right. I mean, would it be interesting for the group to know more about the legislative history of that section? Because I have a law clerk starting next week that we could assign to this.
I think that's worthwhile. I mean,
I do too.
I mostly because I think I'm fine with not carrying it forward, but it's so strange that
I agree.
Where does that platypus come from?
Yeah, and particularly strange, I think, to the point that Mohsen made, that it doesn't include sole proprietorships, which you would think would have exactly the same issue with respect to their creditors.
You're not merging.
Can you merge?
Yeah.
Can you
They're
merge
not
a
an
sole
entity.
proprietor?
Yeah, it's not an entity.
That's a good question.
That's true. That's true.
Yeah, I think that this, if I had to guess, I would guess that this statute came about when they initially adopted the LLC statute back in the 1990s, and somebody was concerned that this would be a surprise to vendors, and they wanted to make sure that they were protecting those people while they were learning about the new features of LLCs. But I would think that most people have figured out by now that limited liability companies exist.
Right.
And they have put in their contracts a requirement to notify you if anything changes about you as a purchaser, or they get a purchase order. And frankly, in my view, a vendor should be looking at its purchase orders. And if it used to be coming in from, A and B general partnership, and now it comes in from A and B LLC, I think that vendors ought to be looking at their purchase orders and saying, hey, wait a minute, what just happened here?
They don't.
Well, right. Although this does trump.
No,
I mean,
but they should.
But if your other contracting party has a contractual duty to notify you and they don't, doesn't actually get you any, that doesn't put money in your pocket. This puts money in your pocket. So, ostensibly. And so that, I get the importance of those contractual notice clauses, but they're, pretty toothless, I think. And so
I rarely see those contractual type clauses outside of loan documentation from institutional lenders, though.
Well,
right.
that may be true.
For the most part, the lender doesn't care until they haven't gotten paid, in which case the fact that they didn't get notified of something doesn't, you know, either the LLC has money or it doesn't, and, you know, having gotten notice or not gotten notice doesn't give you money.
Yeah, and is it reasonable to believe that a transaction hasn't happened when there's constructive notice of that transaction with the Secretary of State? I mean,
Well, that's where I kind of assume that 1H, although it just says notice, I assume that it would have to mean actual notice rather than constructive.
It would have to, because otherwise, every time you file the statement or articles of merger, you cut off the 12 months.
Yep.
You cut it
Right.
off. It makes no sense unless it applies to actual notice, because otherwise it doesn't make any sense.
So I'll assign a law clerk to look at that and report back to the group next time. Okay.
Okay. Two other differences I'll point out that I don't think should be controversial, but I'll point them out and we'll see. Another difference between what's in ORS 63497 and 1026 of RUCLA is that under subsection I, so that's the immediately following subsection, it says that the registration of an assumed business name of a business entity under ORS chapter 648 shall not be affected by the merger. There's no similar explicit language in RUCLA. I think this makes sense why that would be the case. And so I have no objection to simply adding that language as a subsection of 1026.
Yeah, and this is another one of those issues that affects, I think, all the subsequent, you know, statutes here in RUCLA. I'm just curious, is that surplusage? I mean, I'm fine to include it just to make sure we don't, you know, undo something that we like, but from the transactional attorney's perspective, is that surplusage, or, you know, is that otherwise sort of inherent in doing a merger or conversion and what have you?
I would have assumed that it's covered in 5.
Yeah.
Right. Yes, but it's explicit in our statute, and so even if it is, I just think we should continue to be explicit, because the omission of something that used to be explicit creates a negative inference that that's no longer the case.
Are we
Well,
doing
we
that
could
with
also
comments or
just
by
put in our-
including it though?
Yeah, we could just put it in the comment to this section that we view the effect of the Oregon statute subsection I as inherent within the provision James just cited.
Right.
What's the preference? Comment or retain?
Comment.
I like comment.
Comment.
Comment. Okay.
I'm indifferent.
Let me make a note. Okay. Finally, the final difference I'll point out is that RUCLA section 1026 subsection F has this language that doesn't appear in ORS. Do I have the right subsection? Sorry, yes I do. Which this is the final subsection, which says that when a merger becomes effective, the registration to business in the state of any foreign merging entity that is not the surviving entity is canceled. Again, I see this makes perfect sense, and I don't see why it would be objectionable. It's just I don't see similar language in ORS.
I think it's fine.
Okay, no objections there. Okay, well, that covers 1026, unless anyone else wants to discuss anything else.
We're gonna revisit it anyhow when we talk about H 63497 1H next time. So to the extent there are questions or concerns, we can also address things then.
Okay, next time, did you want me to talk about, Valerie, share or what are called interest exchanges, and why I propose that we just omit them altogether?
Who's on the schedule? Do we have you on the schedule for that? Hold on, let me look. Yeah, I have you and Cliff scheduled on that one.
Oh, Cliff, huh? Okay.
Well, you and Cliff, so you're not off the hook.
Yeah, so I mean, I'll tell you, my proposal is that we don't include this part altogether.
Okay.
And so what I would prefer to do is just kind of talk about that. rather than going through the provisions individually. The provisions individually will closely track what we've talked about with mergers and what Jeff will talk about with respect to conversions. This is essentially a different kind of merger.
Okay, so is your thought, Mohsen, that we have that discussion and you convince us in a short period of time to strike it and then we move on to conversions?
That, or if we just choose not to strike it, then we'll move on to conversions and come back to
Okay, yeah. So
interest exchanges.
I think it's reasonable then that Jeff, you and Michael may be up next time.
Okay.
I think you will be up next time because we'll either choose to go with it or not go with it. But if we go with it, I'll need time to then talk through each provision.
Sounds good.
Do we want to give Wilson a chance to talk us out of it first and then go to?
Well, no, that's what he's planning on doing. Is he's planning on talking us out of it, but then we'll move very quickly into conversions.
Okay, so first is talk us out of interest exchanges, then conversions. Before we go, because I know we won't start on conversions, I want to plant one concept related to conversions that was kind of previously discussed, and that is the context of domestication. I think my recollection is we discussed whether we wanted to include it or not. And the thing I just kind of want to point out to plant the seed is that the way the ROLCA conversion stuff is written, it doesn't talk about or permit a foreign LLC converting into an Oregon LLC. And the reason for that is because it expects that you use the domestication. So if we were not to do domestication for some reason, we would have to fix the conversion to allow for foreign LLCs to convert into Oregon LLCs, which is what we do now under ORS.
Right. I mean, I think the idea is that you and Michael will talk through part 4, and then James will lead us through part 5.
Okay, I just thought we at one point discussed whether we were even
we did, yeah. And I think the consensus was sort of loosely at that point that it might be helpful to have the domestication process. So to the extent that we end up saying, no, we hate this language and James talks us out of doing it, then I think we do have to revisit.
Well, conversion, we would have to fix the whole conversion side to permit foreign LLCs.
But let's just look at what's in front of us first.
Okay, all right.
Before we start throwing things out.
So James, don't try to talk us out of it. Otherwise we have to rewrite conversion. Just go through domestication, please.
Okay, so do we have a June meeting set?
Yeah, we do. Give me 1 second to confirm it, but
it looks like the 10th of June I have on my calendar.
What I have on mine as well.
Okay, and then July, what do we have July? I'd like to suggest we move the July meeting to the week of the 12th, just because people may be taking the week of the holiday off.
Sure.
So the 15th or 14th, any preference there? Okay.
One's fine.
The 14th is better for me.
The 14th is better for me as well because the University of San Diego Tax Institute's on the 16th. So it gives me a little bit more space.
Yeah, I have the same problem.
Sorry, I have it down for the 14th.
Okay, great. Okay.
Hello, Valerie.
Yeah.
Valerie, before we go, this is Victoria Johnson, Corporation Policy Manager at Oregon Department of Revenue. Hello. I'm curious to know, circling all the way back to the top of the conversation on Section 1022, looks like A3, the manner and basis of converting the interest of each party. The ROLCA drops the word basis. Oregon statute currently has it in.
Right.
Did this group make a decision on that, or are we revisiting that topic when we talk about conversions in June?
Roberta's smiling because she really
I know it's 3 hours ago.
No, but we decided basis did not refer to tax.
It's not
basis.
the tax issue. It's not tax basis. The basis
But
is.
we don't know.
Well, I mean, I don't think anybody includes tax basis in anything that they file as Secretary of State. So
I think it refers to what is the mechanism or exchange ratio used to determine the consideration paid to individual interest owners.
Right, and I think we decided to go with the ROLCA language is what I have in my notes.
Yes.
Okay.
Unless there's a reason, unless basis is doing some work that we're not aware of.
Right.
So that's what I was wondering. So, and I believe it also comes up again in the conversion statutes, they use, I believe, the same language is used.
Right.
So there will
It
likely
does.
be some opportunity to revisit it just by virtue of the fact that it's in that language. So I think between now and June, I will look into it to see if, in fact, we have any evidence that this is talking about the basis of assets. You know, they're being valued in the conversion process or the merger process, and then report back.
Yeah, and I think too, what Jamie's office, you know, I don't think that tax basis is being reported currently. So, you know, to the extent that I'm wrong about that, that would be good to know as well.
All right, not likely, but okay.
Not our office.
All right.
And you know,
Thank you.
your cost segmentation analysis and your IRS reporting on, you know, transactions and sales and stuff. So, you know, but I don't think they're talking about tax basis there.
I agree with that. I believe that there is a possibility that they're talking about the basis of stock and other items. However, I can give Jamie a call later offline and see what it is that's being reported to the secretary.
That would be wonderful. And then if you find anything that we need to we end up needing to revisit 1023, I think we're all completely open to that.
Okay. All right. Thank you.
Okay, good. Anything else for the good of the order? Awesome. Thank you all so much. I really appreciate you. Have a great rest of the month.
Thanks, everyone.
Happy Cinco de Mayo.
Thanks, Mosin.
And you all.
Bye. Thanks. Good job.
Bye, everyone.
Bye.